I'm rich. The law does not apply to the rich.
The glare of the studio lights in Hollywood, though meticulously managed for broadcast television, possessed a raw, unforgiving quality that the 23-year-old Serafina Vance had never before experienced. This was not the soft, flattering luminescence of the charity gala ballroom, nor the controlled, dignified chiaroscuro of the Senate floor, where her father routinely held court. This was the stark, unfiltered visibility of public accountability, amplified and digitized for millions of afternoon viewers. Serafina, heiress to the sprawling Vance industrial conglomerate and political machine, a dynasty built on oil, media, and the meticulous acquisition of influence, was seated stiffly on a faux leather bench, waiting for her moment of televised reckoning.
This collision of worlds, the insulated, ethereal sphere of multi-generational wealth, crashing into the mundane yet supremely public arena of televised small claims justice, was the immediate and jarring hook that cemented the day in infamy. The inherent contradiction was grotesque, almost physically painful to those who understood the extent of the Vance power. Why was the daughter of a man who could summon congressional investigations with a single curt phone call sitting here attempting to argue over a few $1,000s? This wasn't merely a legal misstep, it was an unprecedented public spectacle, a leak in the airtight seal of Vance privilege. Serafina had approached the preceding weeks with characteristic hauteur, believing implicitly and without reservation that money was not merely a tool for commerce, but the ultimate solvent for all human complication, especially silence.
She had calculated the maximum possible loss in the civil dispute, multiplied it by 10, and offered the resulting figure as a non-disclosure payment. Her belief was ironclad. Every problem had a price tag, and any person, regardless of their supposed principles, ultimately bowed to a sufficient demonstration of financial superiority. This conviction, born and nurtured within the marble walls of her upbringing, was the second, more profound hook that set the stage for her imminent downfall. The Vance Empire, a behemoth constructed across 3 continents, ran on the fundamental principle of transactional immunity. Senator Alastair Vance had long ago perfected the art of preempting scandal, ensuring that any potential friction, whether legal, ethical, or personal, was neutralized not by defense, but by sheer financial gravity.
Whispers of regulatory oversights vanished beneath 7-figure donations. Inconvenient truths dissolved into high-priced legal settlements sealed with punitive confidentiality clauses. The family mantra was clear. If a matter reached public scrutiny, the legal team had already failed. Yet here was Serafina, dressed in a custom-tailored Chanel suit that likely cost more than the plaintiff's annual income, prepared to litigate the destruction of a bespoke antique timepiece on the set of the People's Court. The very notion was preposterous, yet entirely real. The contextualization of the setting demanded an understanding of Serafina's profound isolation from reality. She saw the court not as a venue for justice, but as an irritating, low-level bureaucracy she had been too lazy to properly extinguish. The core problem and accelerating conflict centered on a reckless incident 6 months prior.
During a drunken, high-speed cruise through Malibu Canyon in her new imported convertible, Serafina had accidentally clipped the delivery truck belonging to Elias Thorne, a respected but modest master horologist specializing in rare, customized mechanisms. While the vehicular damage was trivial to her insurance, the cargo was not. The collision sent a priceless, hand-constructed 19th-century regulator clock, which Thorne had painstakingly restored and modified for a client, shattering onto the asphalt. Thorne, a man whose life revolved around precision and dignity, demanded the specific cost of replacement materials and his lost commission, totaling $47,000, a significant, life-altering sum for him. Serafina, incensed by the demand, had initially offered $75,000, not as payment for the clock, but explicitly as a lump sum to make the inconvenience go away and sign the paperwork.
Thorne refused, stating that the price was non-negotiable and that his craftsmanship was not for sale to be used as a cover-up. It was this refusal of the hush money, this astonishing act of principled resistance against overwhelming wealth that spurred Serafina to force the matter to civil court, convinced that the judge would see Thorne's refusal as grasping and unreasonable, thereby humiliating him publicly and justifying her position. But how had this minor incident involving a mere $47,000 escalated into a televised showdown watched by millions? Why had the legion of Vance attorneys, whose salaries exceeded the GDP of small nations, failed to contain this embarrassing seepage? These open loops hung heavy in the air, hinting at a deeper conspiracy of negligence and Serafina's own escalating, destructive hubris.
It turned out the Vance legal team had viewed the case as so insultingly trivial that they delegated it to a junior paralegal, who, operating on Serafina's direct instruction to make the peasants suffer, had mistakenly agreed to the small claims arbitration format offered by the production company, assuming it would be a simple paper dismissal or a quick settlement. They overlooked the crucial factor. Once the camera started rolling, the Vances lost their ability to control the narrative or the verdict. The hidden cost Serafina ignored was the intangible value of Elias Thorne's dignity, a currency her upbringing had never taught her to recognize. The developmental phase of the waiting period was a masterclass in Serafina's mounting frustration and misplaced confidence. She spent the 20 minutes before taping reviewing her prepared notes, a series of legally sound yet emotionally sterile arguments designed to paint Thorne as an opportunist exaggerating his loss.
Her personal assistant, a nervous young man named Marcus, flitted around her, adjusting her posture and offering cold bottled water. In an act of staggering entitlement, Serafina attempted to mitigate her anxiety by attempting to buy off the situation one last time. She discreetly handed a crumpled $1,000 bill to the bailiff, an imposing man whose real name was Rusty, whispering, "Just make sure the acoustics favor my side, please. A little deference goes a long way." Rusty, a veteran of countless tapings and keenly aware of the camera placement, simply stared at the bill, then at Serafina's expressionless face, and dropped the money onto the floor, walking away without a word. The shock of rejection, the absolute cold refusal of her money to perform its fundamental function, to purchase compliance, was a pattern interrupt that momentarily shattered her composure. This wasn't the way the world worked for a Vance.
When she bent down to retrieve the bill, the contrast between the plush, sanitized world of her life and the cheap, slightly scuffed veneer of the TV studio floor became acutely apparent. Her Italian leather gloves touched the dust of the common man's stage. The progression of the conflict escalated rapidly as the studio door swung open and Elias Thorne entered, escorted by the production assistant. He was dressed in a simple, pressed work shirt, his hands, the hands of a true craftsman, showing the permanent residue of polishing compounds and lubricants. He carried a battered briefcase, containing not a team of lawyers, but detailed blueprints and photographic evidence of the ruined regulator clock. Serafina offered him a brittle, condescending smile, a visual representation of her pity for his meager existence. She leaned over and hissed, loud enough for the microphone being secretly tested nearby to pick up, "You really should have taken the 75, Mr. Thorne."
"This whole spectacle will cost you much more than you realize." Thorne simply ignored her, directing his gaze toward the empty elevated bench. Then came the crucial re-engagement, the moment when the absurdity of the situation fully crystallized for Serafina, chilling her entitlement to the core. A sudden hush fell over the crew. The studio lights intensified, achieving maximum wattage. The bailiff, Rusty, straightened his uniform and announced the entrance with the gravitas of a Supreme Court clerk. The door behind the bench swung open, and the diminutive yet immensely commanding figure of Judge Joseph Wapner strode into the frame. This was not a county judge, amenable to backroom political pressure or discreet donations to judicial re-election funds. This was Judge Wapner, the avatar of televised unassailable common sense, whose judgment was simultaneously legal arbitration and public performance art.
As Wapner settled into his high leather chair and the camera zoomed in tight on Serafina's exquisitely manicured face, the reality struck her with the force of physical trauma. This entire forum was designed to be impervious to the very tools her family wielded. There was no purchasing silence here. The entire transaction was predicated on mandatory, unedited sound. The public was about to witness, in high definition, the dismantling of her privilege. The climax of this initial phase began almost immediately upon the bailiff's official declaration. Wapner, without preamble, skipped the opening pleasantries, fixing Serafina with a gaze that seemed to pierce her veneer of custom tailoring. "Ms. Vance," Wapner's voice was firm, resonant, and utterly devoid of professional deference. He possessed the rare ability to make the television studio feel like a genuine court of law. "Your counterclaim alleges that Mr.
Thorne's demand for $47,000 is exaggerated and unreasonable, given your immediate offer of $75,000. Can you explain to the court why you believed an amount significantly higher than the claimed damages was appropriate?" Serafina straightened, relying on the polished, practiced response her paralegal had drafted. "Your Honor, the $75,000 was a gesture of goodwill. It was intended to cover the alleged physical loss, of course, but also to compensate Mr. Thorne for his time and, shall we say, the unavoidable inconvenience of the process. It was a comprehensive settlement package." Wapner leaned forward, his spectacles catching the bright studio light. His reply was not a legal question, but a profound moral incision. "Ms. Vance, in my 25 years on the bench, I have seen many attempts to purchase convenience, but you are attempting to differentiate between the cost of the damaged property and the cost of silence."
Is that not the core of your offer? You were not paying for the clock. You were paying for his immediate cessation of all claims and, more importantly, his disappearance from your sightline. $47,000 was the cost of the damage. $75,000 was the cost of the fix, the eradication of the unpleasant reality that Vance had caused a measurable, tangible loss to a working man. The air thickened. Serafina faltered. Her carefully rehearsed answer dissolved in her throat. She had been called out, not on a legal technicality, but on the very philosophical foundation of her existence. Wapner continued, hammering the point home with chilling simplicity. Mr. Thorne refused the $75,000. He stood on the $47,000 principle of what he was owed, minus your charity, minus your silence money.
This court finds that refusal of the additional $28,000 extremely instructive regarding the character of the plaintiff and rather damning regarding the intent of the defendant. The revelation was brutal. Her attempt to buy Thorne's compliance had inadvertently exposed the moral corruption of her intent, proving the exact opposite of what she hoped to achieve. The conclusion arrived swiftly, echoing across the vastness of the American television landscape. Before the verdict was even officially delivered, the initial public backlash began to coalesce, driven by the instantaneous, visceral reaction of viewers who recognized the arrogance on screen. The taping finished, but the humiliation lingered, a cold, sharp seed planted in Serafina's gut. Senator Vance, already alerted to the disaster by his damage control team, was reportedly apoplectic, not about the money, but about the unprecedented failure to control the narrative.
Serafina realized with dawning, icy clarity that the cost of her legal failure was insignificant compared to the cost of her public exposure. Money had bought her the life she led, but here, on this fake, brightly lit stage, it had failed to buy the one thing she truly needed: invisibility. If money cannot buy silence, then what is its true value? The coming days would force Serafina Vance to confront the true currency of accountability, the kind that cannot be settled with a signature or buried in a non-disclosure agreement. We invite you to join us in Part 2, where the consequences of Judge Wapner's televised indictment begin to ripple through the Vance empire, forcing Serafina to navigate a world suddenly stripped of its monetary insulation. The opulent inertia of inherited wealth usually translated directly into legal and social impunity for Serafina Vance.
For the 28 years of her carefully curated existence, the world had functioned as a series of negotiable transactions. Unpleasantness was merely an external factor whose removal required the appropriate financial coefficient. The assumption
the very foundation upon which the Vance dynasty rested, was that any conflict could be suffocated by an avalanche of non-disclosure agreements, punitive counter-litigation, and ultimately, settlements so generous they function less as compensation and more as enforced silence. This was the immutable law of the Vance universe. Money buys silence. Yet, as the fluorescent lights of the unexpected courtroom venue beat down upon her impeccably tailored suit, a suit whose cost exceeded the plaintiff's annual income tenfold, Serafina felt a chilling, alien sensation. It was not fear in the typical sense. It was the icy dread of a glitch in the matrix, the moment when a fundamental, protective law of physics suddenly ceased to apply.
The first sign that the machinery of suppression was stalling had been the court's bizarre and almost theatrical insistence on public, rapid resolution, stripping away the decades of procedural obfuscation that her father, Lord Alistair Vance, had painstakingly built around the family name. The central figure in Serafina's current torment was not a global regulator or a rival titan of industry, but a man named Marcus Lowell, a middle-aged, perpetually struggling independent artisan whose chief offense was existing inconveniently in Serafina's path during a moment of profound, self-indulgent pique. The alleged incident, seemingly trivial to the Vances, involved the destruction of a specific, non-replicable piece of equipment, an antique lithography press, Lowell's sole means of professional livelihood, and crucially, a deeply sentimental family heirloom. The Vances had initially dismissed the damage as an unfortunate parking mishap involving Serafina's customized armored SUV.
They had offered Lowell $50,000 to sign a standard release and disappear. $50,000, a sum meant to cover the press's replacement value thrice over, plus substantial pain and suffering. But Marcus Lowell, to the Vances' collective bewilderment and rage, had refused. He hadn't haggled. He hadn't demanded $1 million. He had simply looked their high-priced representative in the eye and stated that the equipment was not for sale, nor was the principle of justice. His rejection was not financial, it was existential. This refusal, more than any legal brief, was what truly terrified Lord Alistair Vance. A man who couldn't be bought was a loose thread, and loose threads, in the highly structured tapestry of Vance power, invariably led to unraveling. The narrative crafted by Elias Thorne, the Vance family's lead counsel, a man whose hourly rate could fund Lowell's business for a year, was predicated entirely on the concept of triviality and overreach.
Thorne intended to paint Lowell as an opportunistic fantasist, attempting to extract a ransom based on exaggerated sentimental value. Thorne's usual maneuver involved delaying discovery for months, filing motion after motion designed to financially crush the opposition into submission long before a courtroom was ever entered. He specialized in draining the well of opposition until only dust and despair remained. But this particular venue, overseen by the looming judicial presence that had surprised everyone, functioned at an accelerated, almost brutal pace. Thorne's repertoire of procedural warfare was rendered moot. There was no time for months of discovery. The evidence had been submitted within 48 hours.
There was no room for endless motions to dismiss. The judge had ruled succinctly and quickly that the case had merit based on the clear visual evidence of Serafina's deliberate actions caught on a local security camera, a piece of evidence the Vance team had failed to secure or suppress in time. The development phase of this excruciating public ordeal began with the defense team's desperate pivot. Thorne shifted from pure legal bullying to a character assassination of Lowell, suggesting his refusal to settle proved his true motive was notoriety, not restitution. This line of attack, however, sounded hollow, echoing too loudly in the small, packed courtroom. The core evidence remained. Serafina Vance, irritated by Lowell's slow loading of materials onto a public dock she wished to monopolize for her private usage, had deliberately backed her vehicle into the antique press, reducing it to a twisted ruin of iron and brass.
The accompanying visual footage, now played twice on the courtroom monitors, required no expert testimony. It was a visceral display of destructive privilege. Serafina watched the footage with a strange detachment, recalling the moment not with guilt, but with annoyed justification. Lowell had been in the way. He had dared to assert his minuscule claim to space over her overwhelming right to movement. She had forgotten the entire incident within minutes, moving on to a 7-figure luncheon and a transatlantic shopping trip.
That such a minor lapse in patience could lead to this seismic public confrontation felt like an astronomical injustice aimed directly at her. The escalating pressure was palpable not just within the courtroom, but outside, where a rapidly growing media scrum was devouring every nuance of the proceedings.
Lord Alistair Vance, usually shielded behind layers of corporate security and specialized PR firms, was spending 8 figures a day trying to contain the localized damage. The immediate fallout was the exposure of the Vance mechanism, the systematic deployment of legal intimidation and monetary force to preemptively silence critics and victims. Investigative reporters, drawn by the public nature of the trial, began connecting the dots to previous quiet settlements, environmental complaints dismissed, labor disputes quashed, and minor criminal charges swept clean by high-powered attorneys and 7-figure checks. The fear gripping the Vance family was not merely the cost of this particular judgment, which would be negligible. The fear was the publicity of the judgment. If Serafina were found liable, and if the ruling were delivered with the expected didactic severity hinted at by the presiding judge, it would crack the veneer of untouchability that defined the Vance brand.
Once the public perceives that the Vances can be successfully sued by a man holding a single, mangled press, the floodgates open for every previously silenced victim. Money had bought silence for decades. Now the mechanism itself was on trial. During the noon recess, Thorne cornered Serafina, his usually unflappable demeanor replaced by a strained urgency. "Serafina, you must grasp the seriousness of this. The optics are disastrous. I have managed to suppress the most damning internal communications, the emails where you demanded the press be removed immediately, by force if necessary. But the video alone is a clear case of intentional tort. We need to settle now. We need to buy silence, even if it costs triple, before that man speaks." The man was the judge, whose reputation preceded him like thunder.
Unlike the typical federal judges the Vances dealt with, who revered procedure and complexity, this specific judicial authority was rumored to cut through pretense, focusing relentlessly on the simple, verifiable truth and demanding immediate, transparent restitution. His approach was terrifyingly egalitarian, treating the heiress and the artisan with the same weight of expectation. Serafina, however, remained stubbornly resistant to the idea of capitulation. She viewed the settlement not as a pragmatic escape, but as an admission of fundamental wrongness, an acknowledgement that Marcus Lowell possessed legitimate claim over her. Settle for what, Elias? For bowing down to that pauper? We already offered him more than he'll make in 3 lifetimes. We are the Vances. We do not settle when we are inherently correct in our right to space and movement. Thorne gripped the bridge of his nose, the pressure making his knuckles white.
"Your right to space is what is destroying us, Serafina. Your father is mobilizing every political contact he has to influence the proceedings. But the truth is, this case is too localized, too simple, and too public to be dissolved by a corporate lobbyist in Washington. This is small claims, global audience. It is pure theater, and we are losing the audience." The most profound difficulty for the defense lay in the sheer scale of the disparity. Lowell, representing himself in the courtroom with a quiet, unadorned dignity, spoke only of his work, his history, and the non-monetary value of the press, a machine passed down 3 generations, used to print documents vital to local community history. His narrative was one of craft, legacy, and the simple right to earn a living without interference. Serafina's defense, conversely, was entirely materialistic, revolving around the valuation of the destroyed asset and the enormous wealth backing the defendant.
The jury of public opinion, observing the contrast, was already firmly on Lowell's side. As the afternoon session began, Marcus Lowell took the stand for his final testimony. He was asked by the judge to articulate exactly why he refused the substantial settlement offers. The air in the room thickened, transforming into a vacuum that sucked away all external noise. This was the moment of truth that Serafina had dismissed as irrelevant, the principle over the profit. Lowell spoke slowly, his voice calm but resonant. He didn't rail against the rich or the corporation. He spoke about the principle of ownership and the violation of respect. He detailed the hours he had spent restoring the old machine, the smell of the ink, the feeling of the heavy lever under his hand. He then turned,
not to the Vance's attorney, but directly toward the defendant's table where Serafina sat, cloaked in her arrogant silence. "They offer money to fix the machine," Lowell stated simply.
But money doesn't buy back the hours of my life, the history of my family, or the respect that was taken. Their money is only intended to buy my silence, to make me disappear so they can pretend this never happened. And I cannot accept that, Your Honor. Because if I accept the money, I am agreeing that their convenience is worth more than my existence. I am agreeing to be silenced, and I cannot allow the Vances to use their fortune to erase the truth of their actions." His words hung in the air, a devastating indictment delivered not with fury, but with quiet moral clarity. Serafina felt a genuine tremor of discomfort. This was not the rehearsed script of the people she usually encountered. There were no hidden agendas, no complicated clauses. This was simply a statement of truth, unadulterated by monetary negotiation. It was louder than any screaming headline her father's PR team was desperately trying to bury.
The legal machinery, built by Lord Alastair Vance to guarantee silence, was now amplifying the truth, broadcasting the family's callous disregard for the common man to a national audience. The mechanism had backfired spectacularly, converting a local act of vandalism into a global morality play. The court adjourned abruptly shortly after Lowell's testimony, leaving the matter of Serafina's counter-testimony pending. Serafina stalked out, the heavy realization settling upon her. Her father's strategy, to use overwhelming wealth to enforce non-existence on adversaries, had failed against the one man who valued principle over currency. The great truth of the Vance empire was being undone by a simple, profound refusal to accept a check. Her silence was mandatory, his was not for sale. The next step, Serafina knew, would be her own turn on the stand, a scenario Elias Thorne had prayed would never happen.
She would have to confront the evidence, the accuser, and the terrifying, unblinking judicial gaze focused solely on the facts. The money had failed to buy the necessary silence from the plaintiff. Now the question loomed large. Would Serafina's own ingrained arrogance, her refusal to acknowledge fault, ensure that the truth, when it finally emerged, would be even louder and more damaging? The courtroom, having dismissed all technicalities, was primed for the judge to finally speak, not on law, but on consequence. The Tycoon's daughter was about to learn that some truths cannot be settled out of court. Continue to Part 3 for the climactic confrontation and the judge's intervention.
The hushed tension that had descended upon the courtroom was not the typical, respectful quiet accorded to a presiding judge. It was the sharp, crystalline silence reserved for observing an impossible chemical reaction, the moment where immense, historically unchallenged power met an unexpected, immovable resistance. Alexandra Thorne, seated rigidly beside counsel, felt the collective weight of this silence pressing down, an oppressive realization dawning that her standard instruments of control, the implied threat of endless litigation, the promise of ruinous countersuits, the omnipresent aura of the Thorne financial supremacy, were utterly useless here. This environment, sterile in its judicial simplicity, operated on a calculus she had never bothered to learn, the calculation of demonstrable facts and plain legal interpretation, devoid of the monetary modifiers that typically preceded any interaction with her family's empire. The initial shock of being treated merely as another litigant had crystallized into a chilling dread. Judge Joseph Wapner, having meticulously summarized the defense's opening statements, which relied less on refuting the core facts of the plaintiff's claim and more on asserting Alexandra's absolute right to transactional privacy, leaned forward. His voice, measured and deliberately paced, cut through the atmosphere like a razor through silk, focusing immediately on the document central to the dispute, the so-called Privacy and Reputation Preservation Covenant, a non-disclosure agreement drafted by Thorne legal departments that legal experts universally considered less a contract and more a legally binding declaration of subservience. Ms. Thorne, Wapner began, his eyes fixed on her, bypassing her highly compensated attorney entirely. The defense has argued that this covenant, signed by the plaintiff, constitutes a complete waiver of the right to discuss the events surrounding the termination of his employment, regardless of the alleged circumstances of that termination. Is that a correct summation of your position? Alexandra, coached rigorously to maintain an air of aristocratic detachment, nodded stiffly. Yes, Your Honor, the document is exhaustive. It guarantees my privacy and protects the integrity of the Thorne Group's internal dealings. Breach of that covenant, which the plaintiff has undeniably committed, carries significant financial penalties. Wapner paused, allowing the casual arrogance of her response, the implied equivalence of private integrity with corporate confidentiality, to linger in the air.
This, for the millions watching, was the core philosophical battleground. The right of the powerful to enforce silence, not merely protect trade secrets. Exhaustive, Wapner repeated softly, turning the word over as if inspecting it for flaws. Let us examine the context of exhaustive. The plaintiff's claim, Miss Thorne, is not primarily focused on financial damages resulting from his termination, but on the profound damage to his professional reputation and livelihood caused by an explicit instruction given by a Thorne Group executive, an instruction that directly contravened professional ethics. This instruction, the defense claims, cannot be discussed publicly due to this covenant. Are you suggesting that a generalized boilerplate non-disclosure agreement grants immunity from public scrutiny regarding allegations of corporate malfeasance or indeed personal professional detriment?
The lawyer beside Alexander stiffened, ready to object, but Wapner preempted him with a subtle, authoritative gesture. The atmosphere shifted from adversarial to purely inquisitorial. The focus was no longer on if the plaintiff spoke, but why Alexandra believed she had the right to muzzle him, and furthermore, why she believed this belief should be validated by the court. The Thorne legal apparatus had always operated under the doctrine of overwhelming force. Their strategy was never to win quickly on the merits, but to make the cost of pursuit economically catastrophic for the challenger. The very existence of the Thorne name in a lawsuit was typically enough to signal a protracted, financially draining war of attrition. But here, in this truncated form of civil jurisprudence, those weapons were dismantled. There were no motions to compel endless discovery, no tactical delays, no $10,000 per hour corporate barristers to deploy. There was only the document, the testimony, and the cold, unyielding eye of the law, embodied by a pragmatic judge. Wapner proceeded to deconstruct the concept of purchased silence. He pointed to the specific clause in the covenant that mandated the plaintiff accept a liquidated damages clause equivalent to 5 times his annual salary if any details, adverse or otherwise, were disclosed. 5 times the annual salary, Wapner mused, his gaze sweeping the gallery. This is the price the Thorne Group sets on its own reputation. Yet when the plaintiff attempted to seek new employment, facing the consequences of the alleged events, which he is legally bound not to mention, he encountered what he termed a professional black hole. The silence you purchased effectively destroyed his marketability, did it not, Miss Thorne?
Was the intent of this extensive contract to protect corporate intellectual property, or was it fundamentally to shield the executive class from accountability for decisions that may have been unethical, if not strictly illegal? Alexandra's rehearsed composure finally began to crack. Her response was defensive, bordering on petulant. It is about privacy, Your Honor. My father built this company on the premise that internal affairs remain internal. We have the resources and therefore the right to enforce that boundary rigorously. The plaintiff accepted the terms, accepted the severance package predicated on those terms, and now seeks to benefit by breaking the contract. This declaration, the casual linkage of resources and rights, provided Wapner with the precise opening he sought. The conflict transitioned from a civil dispute over a contract breach into an ethical inquiry into the nature of privilege in a modern legal system. The judge then introduced the testimony of a neutral third party, a former colleague of the plaintiff who had been subpoenaed to testify about the professional climate surrounding the alleged incident.
This testimony, revealed incrementally, detailed a corporate culture within the Thorn Group where silence was not merely encouraged, but ruthlessly enforced through monitoring, fear of professional exile, and the ever-present shadow of Thorn's legal retribution. The colleague painted a picture of the plaintiff being forced into an impossible corner: either comply with an unethical directive and risk his professional license, or refuse, be terminated, and then sign an NDA that would prevent him from ever explaining the termination. The plaintiff testified that he was, in essence, asked to sign a confession of non-guilt in exchange for the right to remain silent about the circumstances of his termination, Wapner summarized, reviewing the notes.
If the core issue involves allegations of a corporate directive that mandated a breach of professional standards, does this court have a duty to look beyond the technical legality of the non-disclosure clause and examine the equity and fairness of the circumstances under which that covenant was signed? Does money buy the right to manufacture narrative, Miss Thorne? The intensity of the developmental phase hinged on scrutinizing the financial leverage. Alexandra Thorne's attorney attempted to argue that the plaintiff was a sophisticated economic actor who was fully compensated for the silence he agreed to sell. He stressed the principle of caveat emptor, let the buyer beware, claiming the plaintiff made a calculated decision to trade truth for guaranteed immediate capital. However, Wapner meticulously tore down this facade of transactional equality. He noted the vast disparity in bargaining power.
A $50 million corporation, backed by unlimited legal funds, negotiating with an individual mid-level manager who had just lost his source of income and faced the immediate pressure of mortgage payments and familial responsibilities. Sophisticated economic actor, counsel? Wapner challenged the Thorne attorney. This is not a negotiation between equals over a commodity. This is a situation where one party held absolute economic control and leveraged that control to compel a specific signature under duress of sudden financial ruin. To suggest that a non-disclosure agreement extracted under such conditions acts as an ironclad barrier to justice requires this court to ignore the economic reality facing 99% of the population. The law, at its best, recognizes that contracts must be rooted in true mutual assent, not the coercion that economic necessity can impose. Alexandra watched this exchange with growing horror. The legal safety net her family had constructed, the belief that any problem, no matter how damaging, could be contained and settled through sufficient application of capital, was unraveling before her eyes. She was suddenly nakedly exposed to a level of scrutiny that money usually diverted or dimmed. Her father, the Tycoon, had always said, "Pay enough and the cameras point elsewhere." Here, in this modest courtroom, the camera was unblinking, fixed solely upon her culpability and her assumption of impunity. The open loops surrounding the original cause of the dispute, the unethical instruction the plaintiff received, were slowly tightening. Testimony suggested that the instruction involved concealing critical environmental impact data related to a major Thorn Group construction project.
If the court validated the plaintiff's testimony, the breach of contract suit brought by Alexandra would look less like the defense of privacy and more like an organized cover-up, using the mechanism of the civil court system as an enforcement arm for corporate dishonesty. The attorney, sensing the devastating direction of the questioning, attempted a procedural counterattack, attempting to refocus the court on the narrow technical definition of the NDA breach. Your Honor, we are here to discuss whether a contract was violated. The motivation of the plaintiff, or the moral quality of the instruction he was given, is irrelevant to the breach of the non-disclosure covenant itself. Our position is clear. He took the money, he signed the contract, he talked. Breach is breach. This legalistic rigidity was the final critical point of contention.
It was the moment of re-engagement, the second hook for the audience. Can strict adherence to contract law override fundamental concepts of fairness and public interest, especially when massive wealth is deployed to silence genuine grievances? Wapner addressed the attorney with a severe clarity. If the integrity of the contract is all that matters, then tell me, counsel, if the Thorn Group paid this individual $10,000 to permanently waive his First Amendment right to criticize the company's products, would you still argue the contract is ironclad?
Where does the court draw the line between a legal transaction and the purchase of fundamental civil liberties? This court is compelled to examine the conscience of the contract. When the consideration for silence appears to be the concealment of potentially harmful public information, the balance shifts dramatically. Silence in that context becomes a co-conspirator to potential wrongdoing. The implication hung heavy. If the goal of the covenant was to cover up actions detrimental to the public trust, the contract itself was voidable on grounds of public policy. This was the final, devastating blow to the Thorne legal strategy. Alexandra Thorne, who had grown up understanding wealth as the ultimate insulator, was forced to confront the harsh truth. Even the most intricately designed legal instruments could fail when confronted by the simple, unvarnished moral calculus applied by a judge unwilling to accept gold as a substitute for truth. Wapner leaned back, a profound weariness momentarily crossing his face, the fatigue of presiding over the constant battle between privilege and principle. The courtroom had reached a point of absolute stillness. He glanced briefly at the clock, acknowledging the lateness of the hour, but signaling that the pivotal moment had been reached.
We have established the factual breach of the covenant by the plaintiff, and we have established the extraordinary disparity of power and the implied duress under which that covenant was signed by the defendant, Wapner stated, his voice now lower, almost grave. We have heard testimony suggesting that the subject of the enforced silence directly relates to matters of public interest and professional ethics. The decision now rests not on the technical language of the document, but on the equitable principle. Can the purchase of privacy shield you from the consequences of actions that undermine justice and accountability? He picked up a small file card, a habitual action preceding a major decision. He held it for a beat too long, letting the full weight of the impending ruling settle upon Alexandra Thorne, who now understood that her family's wealth had bought many things: luxury, influence, convenience, but it had definitively failed to purchase the silence of Judge Joseph Wapner.
The judgment was imminent, but the question of whether money could truly buy silence had already been answered, not by legal argument, but by judicial integrity. The final resolution, however, remained suspended, waiting for the solemn delivery of the verdict that would confirm or deny the universal application of the law. The air in the courtroom, usually a controlled environment of detached legal procedure, had become thick and pressurized, indistinguishable from the atmosphere of a pressure cooker on the verge of rupture. Every subtle shift in posture, every minute adjustment of the expensive silk tie worn by Arabella Thorne's defense counsel, Mr. Sterling, was analyzed not only by the esteemed Judge Joseph Wapner, but by the countless millions watching the televised morality play unfold. This was the moment of ultimate convergence, the singularity where the unbounded power of the Thorne dynasty's wealth met the finite, unyielding wall of the established judicial system.
Arabella, accustomed to navigating the world with the confidence of someone holding a perpetual get-out-of-jail-free card backed by billions, now felt a chilling, unfamiliar sensation: vulnerability. Her father's axiom, the bedrock upon which her entire life philosophy rested, that money buys silence and that silence equates to control, was about to be tested under the harshest possible spotlight. Mr. Sterling, recognizing the precariousness of their final position, attempted one last brazen maneuver, not through the submission of new evidence, for that well had long run dry, but through the leveraging of influence and implied threat, wrapped in the smooth parchment of legal rhetoric.
He argued, his voice resonating with an arrogance that only generations of inherited privilege could cultivate, that the plaintiff's claims, while perhaps superficially distressing, represented an opportunistic assault on the stability and reputation of a vital commercial entity, the Thorne Corporation, and that allowing such trivial, emotionally charged grievances to prevail would set a dangerous precedent,
destabilizing the fiscal infrastructure that employed thousands. It was a thinly veiled attempt to elevate reputation above reality, to assert that Arabella's status made her intrinsically less accountable. This was the ultimate appeal to the unspoken rule of the elite: protect the institution, regardless of the individual truth.
The plaintiff, however, simply sat, quiet and composed, having relinquished the need for vocal defense, trusting instead in the meticulous presentation of facts that had already been laid bare. The ignored cease and desist letters, the aggressive, underhanded tactics employed by Thorne's investigators, the deliberate and documented campaign of character assassination designed specifically to enforce the demanded silence. The quiet dignity of this ordinary individual spoke volumes, a powerful, unspoken rebuttal to the loud, defensive maneuvers of the Thorne machine. Then the final, terrifying silence descended, broken only by the mechanical hum of the cameras capturing the historical moment. Judge Wapner leaned forward, his expression severe, his eye sweeping past Mr. Sterling's facade of professionalism and landing directly on Arabella Thorne, whose pale complexion betrayed the deep, terrifying anxiety she was trying desperately to mask.
The judge did not rush. He began his summation with a methodical, almost academic precision, systematically dismantling the foundations of the defense's case, stone by legal stone. Wapner first addressed the pervasive notion of transactional justice that the defense had so cynically relied upon. He spoke not just of the law, but of the fundamental integrity required for a functional society. He acknowledged the defense's assertion regarding the importance of the Thorne Corporation, but he countered with an indictment of the belief system that fueled its defense strategy. The court, Wapner stated, his voice carrying the authority of decades spent adjudicating human folly and corporate deceit, is asked to consider the reputation and financial magnitude of the defendant's family as a mitigating factor, perhaps even an overriding consideration against the established facts.
We are implicitly invited to view the plaintiff as a minor inconvenience, a necessary expense to be liquidated and silenced, rather than as a citizen whose rights, painstakingly documented in evidence, have been systematically trampled. His dissection continued, growing sharper and more focused. He spent an exhaustive segment detailing the evidentiary failure of the defense to provide any reasonable justification for Arabella Thorne's malicious conduct after the initial conflict. He hammered home the point that the ensuing actions, the surveillance, the targeted smear campaigns orchestrated by Thorne's private security detail, the attempts to manipulate employment records, were not errors of judgment, but calculated acts of oppression aimed at ensuring the plaintiff's economic and social ruin solely for the purpose of preserving Arabella's untarnished public image. This was the core of the malfeasance, the weaponization of wealth to enforce a narrative of innocence where none existed.
The testimony presented here, Judge Wapner continued, meticulously turning the pages of his notes, demonstrating the thoroughness of his review, reveals a pattern of behavior consistent with the defendant's fundamental assumption that civil liability, when incurred by those of exceptional means, is merely a fine, a negligible tax on the convenience of impunity. The court rejects this assumption entirely. He stressed that the law recognizes no qualitative difference in the value of an individual based on their net worth or social standing. The dignity of the average citizen, the ability to live free from undue harassment and intimidation, held the exact same weight as the protection of corporate assets, and in fact, in cases of documented malicious intent, the need to protect the vulnerable outweighed the perceived status of the aggressor. Arabella Thorne watched, her initial annoyance curdling into genuine horror.
She had faced lawyers who were timid, judges who were deferential, and entire systems that buckled under the weight of her father's influence. But Wapner was neither timid nor deferential. He was an immovable object of objective, dispassionate analysis, immune to the gravitational pull of the Thorne fortune. He was not just ruling on the case, he was delivering a moral judgment on the entire culture of aristocratic entitlement she embodied. The development phase of the ruling felt like an eternity. Wapner spent an unusual amount of time on the calculation of damages, emphasizing that simple compensatory awards were insufficient given the documented malice and the brazen attempt to suppress justice. He detailed the plaintiff's loss of earnings, the psychiatric costs incurred due to sustained harassment, and the quantifiable damage to reputation, meticulously arriving at a substantial compensatory figure.
But it was the final component of the award that carried the true sting: the punitive damages, designed not merely to compensate, but to punish and deter. This was the crescendo. This was the moment of rupture, the shattering of the gilded cage Arabella had always mistaken for reality. The defense argued vehemently that this court should consider the defendant's youth and status, Wapner announced, his voice rising slightly, cutting through the heavy silence. The court has considered these factors. However, the severity of the conduct, the intentional, prolonged deployment of vast resources, not to settle a debt, but to permanently silence a truth, demands a response that transcends mere recompense. To truly deter such arrogant abuse of power, the penalty must be significant enough to register even against the magnitude of the Thorne dynasty's aggregated wealth. He paused, allowing the weight of his words to settle. Arabella's breathing became shallow and ragged. Mr.
Sterling, seeing the inevitable disaster looming, visibly slumped, his posture transforming from aggressive advocate to defeated functionary. Therefore, Judge Joseph Wapner declared, the clarity of his judgment echoing across the broadcast airwaves, in the matter before the court, concerning the malicious and oppressive actions of defendant Arabella Thorne against the plaintiff, the court finds decisively in favor of the plaintiff. Judgment is hereby entered for the plaintiff in the full compensatory amount previously calculated, totaling $550,000. That number, while substantial, elicited a slight nervous relief from Arabella. Her family paid more than that for annual landscaping. It was painful, but manageable. It was merely the cost of doing business. But Wapner was not finished. He continued, the second half of his declaration a thunderclap against the fragile edifice of her confidence.
Furthermore, and of critical importance for the deterrence of similar conduct by those who believe their financial resources grant them immunity from ethical and legal standards, the court awards punitive damages. Wapner held the gaze of the camera, delivering his closing statement directly to the public. The message aimed squarely at every tycoon who had ever believed they could buy the silence of their victims. These punitive damages are set at a figure commensurate with the defendant's capacity to absorb true financial consequence, ensuring the message resonates unequivocally, that in this jurisdiction, the pursuit of justice is not a marketable commodity. He delivered the final figure, the number shocking the courtroom into a collective audible gasp. The punitive damages are hereby set at $3,500,000. Total judgment against the defendant, Arabella Thorne, is $4,050,000.
The clang of the gavel was not just a legal formality, it was the sound of Arabella's inherited worldview fracturing completely. $4 million was not crippling to the Thorne empire, but it was massive enough to necessitate the involvement of her father, Reginald Thorne, demanding explanations, documentation, and accountability. More importantly, it was a public, undeniable statement that she was wrong, and that the system, in this instance, had worked precisely as intended, prioritizing truth over treasury. The immediate aftermath was chaotic. Arabella rose too quickly, knocking over a glass of water, the small mundane accident underscoring the magnitude of the professional disaster. Her face, usually sculpted by an innate confidence, was contorted by raw, unprocessed fury and humiliation. She had lost. Not to better lawyers, not to superior financial maneuvering, but to the simple, brute force of undeniable truth presented before an incorruptible judge.
The money had not bought silence. It had purchased an exceedingly loud, definitive verdict. Mr. Sterling immediately began whispering frantic appeals about the possibility of appeal, stressing procedural errors and the possibility of negotiating the punitive damages down. But for Arabella, the legal nuances were meaningless. The fundamental hard truth had been delivered by Judge Joseph Wapner.
The Thorn name, for the first time in her memory, had failed to command obedience. The silence she craved was now permanently beyond her reach, replaced by a deafening roar of consequence. The plaintiff, in stark contrast, offered no exuberant display, no gloating victory dance. There was only a quiet, profound relief, the profound relief of an ordinary citizen who had weathered the storm of an aggressive, well-funded corporate war machine and emerged with their rights vindicated.
The symbolic weight of the verdict was immeasurable, a reminder that the scales of justice, though often slow and often strained, could, under the right conditions and the right jurisdiction, balance truth against overwhelming power. As Arabella was ushered out, her movements stiff and involuntary, she was immediately enveloped by the media scrum waiting outside the courthouse doors. The flashes of 100 cameras served as strobe lights, illuminating her public shaming. She saw the headlines already forming in the minds of the reporters. Tycoon's daughter hit with multi-million-dollar ruling. Wapner delivers justice against billionaire bluster. This was the public exposure her father had always warned her against, the kind of scandal that tainted the carefully curated Thorn image.
The ultimate payoff was the realization that money buys silence is not an immutable law of the universe, but merely an expensive, conditional privilege, easily revoked when confronted by integrity. Arabella Thorn, the daughter raised in the protective cocoon of absolute fiscal control, was left with the inescapable understanding that some truths are simply too loud to suppress, regardless of the size of the accompanying check. The courtroom drama, televised and archived, stood as a permanent, undeniable testament to her failure. The silence she had tried to purchase had rebounded, now echoing as a permanent mark of public accountability. The story of the Thorn dynasty's failed attempt to exert absolute control over the legal system through monetary means resonated far beyond the procedural confines of the courtroom.
It became a cautionary tale, a powerful journalistic narrative reinforcing the fragile yet persistent ideal that systemic justice, even if rare, can indeed be blind to the zeros in a bank account. For Arabella Thorn, the lesson was delivered not through a discreet private settlement, but through a humiliating televised public judgment, a consequence she could never truly pay away. The rule of law had spoken, and its voice was louder than any amount of money. The challenge now remains whether this single, definitive ruling by Judge Wapner could truly shift the pervasive culture of impunity enjoyed by the nation's wealthiest elite, or if this victory, while satisfying, would remain an outlier in the long, continuous fight for truly equitable justice.